Welcome back to the Oscar Pistorius Trial Channel. Let's continue tonight's round-table debate with advocates Mannie Witz and Khanya Jele and former High Court Judge Greenland. If you do have questions, you tweet them to us using the hashtag roundtable199. Now, just before the break, Mannie Witz was going through a defence called, and I'm going to have to read this, temporary non-pathological criminal incapacity. And he read some sections of Oscar Pistorius's cross-examination in which he made reference to shooting at the door. Before he knew it, he had fired 4 shots at the door. Mannie says this goes directly to this defence, and if it succeeds, could result in an acquittal. So let's now test it. How have our courts accepted this kind of defence in the past? And I suppose you've got a very good insight, Mannie, because you were involved in these cases.
I was involved in some of the cases.
Okay, well, let's go through it then. I've got State versus Ingram here. This is the case of the man, this comes from 1991, wasn't it?
Correct.
Where Ingram and his wife had a fight and he shot her.
He shot her in front of the children. Yeah, Raymond Joffe was my attorney in the matter, and we put a lot of work into it.
They were both drunk. There was a history of drunken
abuse, etc., etc. And then he fired 2 shots at her in the room in front of the children.
Yes.
Unfortunately, what happened is, at that particular stage, the first one missed, the second one hit her in the shoulder. And the door was then locked. He then took the children, left the house, drove to Germiston from Bryanston. When he got to Germiston, he left the kids with his parents. He then went to the police with the gun and handed himself in. And he was very, very inebriated. He was drunk as anything. But he managed to drive, take the children, and do certain conscious acts. What happened very, very simply is the person who worked in the garden heard crying, went there, managed to break the door down because she couldn't get to where the phone was, rushed her to hospital, and she lived for the following day. Took her to the general hospital. They did an operation, tried to remove the bullet. She then shot an embolism and she died. And they then charged him with the murder of his wife.
Okay.
Right at the beginning, when we saw him and when Raymond Joffe was dealing with him, he sent him to a psychiatrist, David Shevel. Meryl Forster, funny enough, was the chief psychiatrist of Sterkfontein. She was our opponent in the matter. Mm-hmm. And very, very simply what happened there, we had him tested, we did all the various tests, and we raised the defence at the outset of this temporary non-pathological incapacity coupled with the alcohol. And we led the evidence. He was cross-examined. Meryl Forster gave evidence for the state, and the matter went all the way to the Supreme Court of Appeal. And very, very simply what happened, they looked at how this defence worked, and they said, for that moment in time when he fired the 2 shots, did he have the necessary culpability to distinguish what is right, what is wrong, and was he able to control his actions? And at the end of the day, the court found that there was a diminished responsibility. They confirmed that he was guilty, but they assisted him in regards to the sentence, and he was sentenced to corrective supervision.
But did they accept a defence of non-pathological criminal incapacity?
They didn't accept it in that particular case. They preferred Meryl Forster's evidence, who gave evidence to the opposite effect, and said, look at his actions before, look at his actions when it happened, and look at his controlled actions afterwards, getting in a motor car, consciously taking the children, dropping them at his parents, then going to the police station and handing himself in. All those conscious acts. So what the law has said, and there's a lot of cases where people have got off, not guilty, acquitted, on the temporary non-pathological incapacity in the Appellate Division Supreme Court of Appeal. And what the courts say, you've got to very carefully scrutinise the evidence of the accused. Look at his actions before. Look at really 4 aspects. Is there a trigger mechanism? What set him off? Was it rage? Was it emotions? Was it, for example, in our case, the hypervigilance, that he's hypervigilant? Was it his stress disorder? Did all this contribute? And I've read out what his evidence is. And if this contributed, can you still hold him criminally accountable?
But how is this tested by the court? How does the court know that this is non-pathological criminal incapacity? Is it the evidence of psychiatrists?
Psychiatrists coupled with the evidence of the accused himself.
Absolutely.
That's how it works.
They look at both. They definitely look at both, because they have to weigh. I don't know if you noticed, but a lot of discussion has taken place about, well, what do the facts show? But the facts show this and the facts show that. The reality is that on one hand you will have that expert testimony that gives you the insight that the lay court, as the judge called it, cannot in and of itself make a determination on. And on the other hand, you'll look at the facts and you'll make a decision. What do the facts actually show? How do the facts fit into the concept that the psychiatrist might come up with regards to the state of mind of the accused under those circumstances?
And as regards Ingram, just to round off the facts, what the Court of Appeal found was that he still had sufficient capacity to restrain himself. That was the basis on which the appeal failed.
Okay.
But luckily there was the diminished responsibility, and they obviously came to his assistance in regard to sentence, and he didn't get a custodial sentence. And I think at the end of the day, if one looks at the Act, and I think that's really, if I can hazard a guess.
I want you to hold it there, because we are going to look at the Act to see what happens next. But I want to know, is there a case, an appeal court case, Supreme Court of Appeals or AD, whatever it was in those days, where this defence of temporary non-pathological criminal incapacity, I will be able to recite it at some stage without looking, has it been accepted?
Accepted in many cases.
I've got another case here, State versus Edie. Is that the one where...
Edie, they didn't accept it because they looked at his conscious acts. That's the man with the hockey stick, the road rage in Cape Town.
Yes.
And he claimed right at the outset, he said, that's part of my defence. He called psychiatrists. They called the head psychiatrist from Falkenberg, which is the mental hospital in Cape Town. They called various psychiatrists, and there was a big debate and dispute between them whether you accept it or not, and whether you're opening floodgates. Everybody gets into a rage, everybody loses his temper, heightened emotions, etc. The same as in this case. Can you then use it as an excuse to say I'm not culpable in law for that split second in time when I fired the shots?
One of the interesting things that this brings up, and I don't want to cast judgment on any choices that have been made, but what I think Mannie is highlighting is strategic choices that are made out the outset about what your defense is going to be and what case you're going to put forward are fundamental. Anybody right now thinking, I want to be a lawyer because it's so much fun to stand up in court. One of the most important aspects of this job is your strategic choices. You might find that the facts and the information your client give you options. There isn't just one story you could tell. Okay, so we could put it that way, or we could put those facts forward and put it that way. You don't always have a single option, and very often you have to make strategic choices, and those strategic choices are fundamental to your success, the options that you have going forward, and more importantly, how long a trial will take, and just what you can do to protect your client's interests.
Yes.
And it's very significant that I think what this turn of events has shown is the extent to which those strategic choices can have an impact, positive or negative, long term.
You also raised the issue, you were talking about not wanting to open the floodgates. For anybody, Chris, and I'm going to ask you to answer this one in 1 minute if you can. The danger of something like this is that if it isn't properly scrutinized and tested, then yes, he's perfectly sane up until the moment somebody commits a criminal act, and he's perfectly sane thereafter. And says, well, only in those 2 minutes when I committed the criminal act, sorry, I was incapacitated. Wouldn't everybody want to plead that? You've got to be so careful in the AD.
Yes, absolutely, and this is why I've banged on as regards this issue, where my colleagues have quite correctly said that provided the defense might reasonably possibly be true, then it has to succeed.
Yes.
And I've said that it's not as simple as that.
Yes.
The court still has to accept that defense. Otherwise, what you said is correct. I could just make up a story which might reasonably possibly be true and be acquitted. We'll
find out what happens next. And Mannie Witz, apart from bringing us all the case law, he's also brought with him a chunky little book called the Criminal Procedure Act. And we'll have a look at this and the possible avenues that are now open to Oscar Pistorius, because obviously this order has yet to be finalized. It's only going to be granted on Tuesday. We'll continue this discussion after the break.